So this is the first of two videos that takes a look at the legacy of the fourth Chief Justice of the Supreme Court, a Federalist named John Marshall. And we can definitively say he was a Federalist because it was his political beliefs that helped him achieve his status on the court. Now, when John Adams lost the election of 1800, he was technically president for another 5 months. This is known as a lame duck politician, where you still technically hold office, but you are somewhat powerless because you know you're going to be leaving. Back then, presidents were lame ducks for 5 months because the election was in November. You didn't take office until March. That was changed. Now the election is November and January is the inauguration, but Adams is a lame duck for exactly 5 months. Now his party, the Federalists, have lost the presidency and they've lost Congress. So he was determined to allow the Federalists to maintain control of the federal courts because federal judges served in good behavior, which means for life. Adams and the other lame duck Federalists passed what was called the Judiciary Act of 1801, which added more judges to the bench, basically more Federalist judges. Now, to appoint new judges, Adams stayed up well into the night of his final day as president, signing commissions, and he signed these by candlelight. That gave rise to this phrase here, the so-called midnight judges. Now, however, due to the timing of these signings, since they were so last minute, not all of the commissions were delivered when Adams was still president. Some were not even delivered until Jefferson had officially taken the oath of office. And that's where this stems from. Some of these commissions, meaning the orders of these judges to, be a judge, they were delivered too little too late. Now, William Marbury was appointed as Justice of the Peace in Washington, D.C. James Madison, the same James Madison who's father of the Constitution, father of the Bill of Rights, that James Madison is now the new Secretary of State under Jefferson. He refused the commission of Marbury. He refused it, said it wasn't delivered on time. Marbury sued and petitioned for what was called a writ of mandamus. And writ of mandamus is a court order to do something specific. In this case, he wanted the Supreme Court to order Madison to give him his job. So Marbury is the guy who thinks he should have a job as a judge. Madison is the Secretary of State. That's where the name of this case comes from. Now, Chief Justice John Marshall definitely has a dilemma. This case is going to be ruled on about 2 years later, February of 1803. Now, Justice Marshall was actually a cousin of Thomas Jefferson, but they weren't really fond of each other, right? They disagreed on policy. And to the casual observer, whatever Marshall does, he's going to look weak. If he simply says to Marbury, why, yes, you're entitled to your commission. You should have this job. He's going to look weak because he can't enforce it. If he says yes to Marbury, the president might simply say no. And the court looks weak. If he tells Marbury, no, you're not entitled to this job, then it would seem like the Supreme Court, which is supposed to be an independent branch of the federal government, is subordinate or bowing down to the president, somewhat underneath them. Still looks weak. So really, no matter what Marshall does, it appears as though he's going to look exceptionally weak. What he ends up doing was actually pretty smart. And his solution is going to set the precedent for the concept of judicial review. Now, if you look here, if you want to simplify it, Marshall basically says, yeah, I could do it, but I can't, and I won't. You see, he ruled that the Supreme Court, absolutely 100% did have the right to issue this writ. So yeah, Marbury, you are correct. However, he said that the court would not do it because the law that allowed them to issue it, a law from over a decade earlier, the Judiciary Act of 1789, this law that allows them to do it went beyond the original intent of the Constitution, and that law was illegal. So in effect, what Marshall does is he takes a case that was about a man who wanted his job, William Marbury, and the end result is that the Supreme Court now has this power to review laws and determine if they're constitutional, determine their legality. This is something that actually was mentioned and alluded to in one of the Federalist Papers as something that the court should be able to do. It doesn't say anywhere in the Constitution that the Supreme Court can do it, but Marshall made the ruling, and by and large, everybody accepted it. So the first big impact that Marshall makes is this ruling in Marbury versus Madison. The other significant case that we'll address is this concept, and you can see up here, of Marshall saving the bank. Now, this comes from a case that was called McCulloch v. Maryland, and it centers around the Second Bank of the United States. Now, the Bank of the United States received a charter in 1816. A charter, remember, it's that document meaning you're allowed to do something. You're allowed to operate. And the constitutionality of this charter was called into question, just like it had been all of those years before. So nearly 3 decades ago, when people said, hey, Washington, a bank isn't legal, the same case is being made right now. Now, it's not as if there was one bank. Just like how banks today, like Associated Bank or Nicolay Bank, you have a main branch and then other branches all over. That was the case with the Bank of the United States. There was a branch located in Baltimore, Maryland. And Maryland did not want it to exist at all. So they tried to levy a tax on the bank. That's where we see Maryland attempts to tax it. James McCulloch is the cashier of the Baltimore branch. All right, so he works at this bank, and he felt that the ability of a state to tax a federal institution was illegal. So he just refused. He said, no, not going to do it. The case makes it all the way to the Supreme Court, and Representative Daniel Webster actually ends up arguing in front of the court in favor of the bank. So McCulloch is the cashier of the Baltimore branch of the bank. Maryland tried to tax it. That's where the name, in effect, comes from. Ultimately, Marshall ruled that a bank was indeed constitutional. Now, Webster had argued in favor of a broad interpretation, stating that the Constitution was more of a general outline than a document meant to enumerate, meaning number or list all powers of Congress. So just because it's not explicitly there doesn't mean that Congress can't do it. Maryland countered by stating that a bank is not only not mentioned in the Constitution, but there was zero evidence whatsoever that the framers even had a bank in mind. By using the necessary and proper clause, that Article 1, Section 8, Paragraph 18, Webster dramatically expanded the powers of the federal government, and Marshall, as a Federalist, agreed. Webster argued against the tax as well. So he argues for the bank and against the state tax. And he actually said an unlimited power to tax involves necessarily a power to destroy, because there is a limit beyond which no institution and no property can bear taxation. Marshall agreed. He agreed that a state cannot tax a federal institution, and he even used Webster's language in his decision. That's why you see this famous image, the power to tax. involves the power to destroy. It's attributed to Marshall because he used it in the decision, but all told, those were Daniel Webster's words when he argued it. The ruling on the bank will provide Congress the power to use enumerated powers of Congress to justify implied powers of Congress. All right, so because of this, if there's something written for Congress to do, they can do something else to carry those powers out. So the two M&M cases, we have McCulloch v. Maryland, we have Marbury versus Madison. Both were decided by Chief Justice John Marshall.